Good morning. My name is Jeff Stauffer, Community Relations Director with Elville and Associates, and welcome to our webinar, Estate Planning for the Individual, with our presenter, partner and senior estate planning attorney, Olivia Holcombe-Volke of Elville and Associates. Olivia may have a few additional words to say about herself, but I'll say that our clients think the world of her because of her extensive experience and the care and time she takes with her clients. And of all the attorneys that we could choose from, my entire family and I have had Olivia take care of our estate planning over the years. So I think that says something right there about Olivia's expertise. It's been a pleasure working with her, both personally and professionally, over the last 6 years or so. So really briefly, the way this will work today is you as attendees are on mute. However, there is, as you'll see, a box on the right of your screen where you can ask questions, and we encourage questions. And we'll work to field those questions throughout the presentation, as well as at the end in a timely manner. For certified financial planners and CPAs on today's webinar, you may receive 1.5 continuing education hours for attending. And so for my records and per the requirements of the CFP Board of Standards, please email me your board ID. And also for CFPs only, I'll need the last 4 digits of your social security number as well. So please try to get that over to me in a timely manner. Also, everyone will receive a survey immediately after the presentation. And we ask that you please just take 2 minutes to fill this simple survey out. It's going to offer us valuable feedback about the presentation. And you also have the opportunity to request a time for a consultation with Olivia to discuss your planning needs. And we look forward to being a resource here for you at Elville and Associates. And there's also nobody better to guide you through the planning process than Olivia. So very briefly, an overview about our firm, if you're not familiar with us. We were founded in 2010 in Columbia by principal and president and lead attorney Stephen Elville. We have a number of different practice areas here at the firm, which include estate and special needs planning, elder law and elder care planning, estate and trust administration, asset protection, guardianship and a litigation department, as well as tax planning. We have 6 attorneys, soon to be 7, 13 staff members in 5 locations. I'm coming to you live here from our Columbia location, and it is raining. Hope you're staying safe in your homes or offices today. Our mission, as it always has been and always will be, is to provide practical solutions to our clients' needs through counseling, education, and superior legal technical knowledge. We focus on education a lot here at the firm, for those of you that are familiar with us, and we do that through our planning processes with our clients, through over 100 educational workshops in the communities we serve each year, and also by way of our accredited client care program. We're one of only a couple firms in the state of Maryland that has an accredited client care program, which is very robust, through the Client Care Academy in Boston, Massachusetts. So just a little bit about Olivia, if I can go to the next screen here. Olivia is a partner and senior estate planning attorney with Elville and Associates, and her work is centered in estate planning, elder law, estate and trust administration, special needs planning, and asset protection. She speaks regularly and each year presents at numerous workshops, conferences, and continuing education events. A little bit about her background. She was named to the Maryland Rising Stars list by Maryland Super Lawyers in 2017. She was named 10 best for client satisfaction in estate planning by the American Institute for Legal Counsel in 2018 and 19. She's very active as far as volunteer work, which we're very proud of Olivia for, and that's very important to her. She is a board member for the Women's Law Center of Maryland and is the chair of the Judicial Selections Committee, a volunteer attorney for the Maryland Volunteer Lawyers Service. She is a founding member of the MBLS Community Advocacy Network and was also named the Volunteer of the Month for that network in May 2019. And she also provides trainings to volunteer attorneys on advanced directives, financial powers of attorney, wills, and deeds. So a little bit of background about us and your presenter today. And so with that being said, we're going to go ahead and get started. Also want to mention that Elville and Associates works every day with the ideals of client education, collaboration, and compassion in mind. And you should expect nothing less from us anytime that you work with us or come into contact with us. or any company you work with for that matter. So keep that in mind, and that's something that we really take pride in here at the firm on a daily basis. So let's start off with a brief poll to get you engaged and learn a little bit about the audience that we're working with today. This is an anonymous poll. It's just gonna get us an idea of what's called, what is the state of your estate planning? So I'm gonna go ahead and launch this poll. It should pop up on your screen and just take just a few seconds to note your response so we can get an idea of the audience that we're gonna be presenting to today. So I'm gonna go ahead and launch that. And the options are, I don't know where to begin, help me. I established a plan a while ago, but it needs updating. My plan is signed, sealed, and delivered. I'm all set. Or I'm here to learn how to educate my clients. I'm a financial advisor. So if you can just take a minute to note your answer, that would be wonderful. See the votes coming in. And give it another few seconds here. And we have about 3/4 of you having voted, so we're going to go ahead and close that poll out. 20% said, I don't know where to begin, help me. 25% said, I established a plan a while ago, but it needs to be updated. 30% said, my plan is signed, sealed, and delivered. And 25% said, I'm here to learn how to educate my clients. I'm a financial advisor. So thank you for participating. We appreciate that. That is a good segmentation of people that are here today. So a little bit of everything. So that's nice to see. So with that being said, I'll turn it over to Olivia. Welcome, Olivia. It's always great working with you. Hope that you're staying safe today in the storm. And I'll turn it over to you, and I'll turn off my camera.
Excellent. Thank you so much, Jeff. And yes, good morning, everyone. I hope wherever you are, it is watertight. I'm looking out at a very rainy Baltimore City view at this moment, and I was actually thinking 5 months ago when I gave a webinar on estate planning, the universe had provided me with a good reason to encourage people to do their estate planning and do it soon, which was COVID-19. And today we have a tropical storm giving me yet another good reason to say, do your estate planning and do it soon. So what we've learned over the last 5 or 6 months is that the universe does not follow any plan that any of us may have laid, which is why it's a good idea to make sure that we've covered all the bases and that we are prepared for whatever may happen at whatever time. And so today, I'm going to talk specifically about estate planning for the individual. Estate planning for the individual is something that I will cover both estate planning as an overview of what I mean by that term, but then also talking specifically about certain nuances that do come up when we're doing estate planning for an individual. If I can get my screen to cooperate, there we go. All right, so as a starting point, an introduction to what is meant by the term estate planning. And for those of you who have attended webinars that I've given in the past, a lot of this will be familiar, and I apologize for the repetition, but I find it is remarkable how often the repetition actually serves a good purpose, because many of us do not spend all day, every day thinking about estate planning. I do, you hopefully do not. As a result of that, it's a good idea to refresh when we're going to talk through what estate planning means and the different perspectives and nuances you might want to think about with regard to your own personal estate planning. I find that it's helpful to start with an overview of what estate planning means. So estate planning does not simply mean what happens to my stuff when I die. Estate planning is also entirely relevant to planning for what may happen to you and your health and your assets if you are still alive and you become incapacitated. But estate planning also involves planning for the disposition of your property at death and for the protection and care of those who may be dependent upon you. And I say this because often people do think of estate planning as simply a death plan, a what happens when I die. And when people think about it that way, it's quite easy to feel like, what do I care? I'll be gone. Or to feel like that's a far distant reality, so I don't need to worry about planning right now. But the fact is, first, we all know that none of us have a crystal ball and no way to predict the future. But second, estate planning is also meant to protect you if you are still alive, but you become incapacitated. And the time is now to be ready for what might happen. So when is estate planning necessary and/or relevant? Often people think, oh, it's only for the elderly, and I'm not elderly, so I don't need to worry about that. Or that it's only for the wealthy. So people who say, well, I really don't have anything. Again, this is where I would emphasize, do you care that if you are still alive but potentially incapacitated, does it matter to you that there's a plan that you put together where you've actually outlined what will happen and who will be in charge? And that is not something that's limited to only the wealthy. And then often I hear people say, well, I'm simple. I have simple assets. I have a simple life. I don't have anything overly complicated that I need to plan for. Again, the simplest thing in the world is I personally care what happens to me and my health if I become incapacitated. That's not overly complicated. That's applicable to everyone. So estate planning is not something that should be thought of as only necessary for the elderly, for the wealthy, or for those with complicated situations. It truly is something that is applicable and important for everyone. So talking a bit more about incapacity planning, and here I reference avoiding guardianship. So let me just talk about what I mean when I say that. Guardianship is a term that many people are familiar with in terms of minor children. So guardianship of a minor child, that is certainly an applicable place for that word, but guardianship is something that is also relevant to adults. Adult guardianship is something that happens when an adult, meaning over the age of 18, loses their mental capacity and never signed documents giving authority to someone else to act on their behalf with regard to health care and with regard to finances. In that circumstance, if you're dealing with a now incapacitated adult who no longer has the capacity to sign legal documents giving authority to someone else, what ends up happening is that the court has to get involved, and the court appoints a guardian to be in charge of that incapacitated person's health and finances, all of which is overseen by the court. Basically, it means being babysat by the court. Every adult with whom I speak agrees that they never would want that to happen to them. And so when we're talking about incapacity planning, what we're really talking about as a baseline is doing everything possible to avoid guardianship. And the documents that accomplish that, the basic fundamental documents that accomplish that, are called the Advanced Medical Directive, and then I reference something called the MOLST, which I'll talk about a bit more, and then powers of attorney, which deal with finances. And there are 2 power of attorney forms that I provide for clients, and I'll talk a bit more about those as well. So healthcare decision-making, in Maryland, the document that we utilize is called an advance medical directive. Some other states refer to this as a healthcare power of attorney. People often ask, where is the living will involved in all of this? And the answer is that that's part of the advance medical directive. So in Maryland, the advance medical directive is a document that covers not only appointing agents, meaning appointing the person or persons who you would want to be your voice to the doctors and to be your decision maker if need be in certain healthcare situations. It also allows you to specify at what point your agent has the authority to speak on your behalf. And that's a distinction that I find interesting in conversation with people. Across the board, it's not ever a matter of whether or not you're incapacitated. It's only going to be effective if you're incapacitated. No one else is going to be allowed to make healthcare decisions for you if you have mental capacity for yourself. But the distinction in the advanced medical directive with regard to the effectiveness of your agent's power really pivots on what level of proof of your incapacity do you want your agent to have to obtain? And that's something that I really talk through with clients because that's a source of concern for them. No one wants to give up their autonomy unless and until they need to, or they've given up their autonomy simply by becoming incapacitated. The advanced medical directive also allows you, in what's called the living will, to actually give end-of-life decisions and treatment instructions, so that if you are in certain end-of-life situations, you have given written instructions to your healthcare agent regarding what you want them to do. And in Maryland and in most places, those typically are 3 distinct situations: terminal condition, persistent vegetative state, and what's called end stage condition. But if you don't have a written document, then you have not put in writing what you would want someone to do if you were ever in those situations. And if you imagine ever being in those situations and not being able to communicate, if no one has written instructions on what you would want done, and no one has the authority to actually speak on your behalf and tell the doctors what to do in those scenarios, you're really left completely unprotected and left without any sort of control over your own health care if you were ever in those situations. So putting it in writing is vital. The advanced medical directive also allows you to go into more non-clinical preferences and personal preferences with regard to food, entertainment, visitations, if you want pastoral counseling. I've had clients say, I'd like to have my dog visit if possible. None of that information is known if you don't put it in writing. And the advanced medical directive also allows you to say whether or not your healthcare agent actually has the discretion to make a different decision than what you've said in writing if there is something different at the time that would be in your best interest. And finally, it allows you to cover organ donation preferences and what you want done with your final arrangements. Now, the advanced medical directive does not cover DNR. So clients regularly say, where is the DNR aspect in this document? That is not covered in the advanced medical directive. In Maryland, that is actually covered in a document called the MOLST form. MOLST stands for Medical Order for Life-Sustaining Treatment. It is a medical order. It is signed by a doctor. You do not sign it for yourself. It is signed by your physician. And it sets forth your DNR preferences. What I always recommend that clients do is, number 1, talk to their primary care physician about the MOLST form. And number 2, we provide clients with the information that they need to read more about MOLST in Maryland and to fill out a worksheet that is meant to guide a future physician in completing the MOLST order form based upon your actual preferences. The financial aspect of things, again, talking about incapacity planning, talking about a period of time where you are still alive, but you need or want someone else to be acting on your behalf. On the financial side of things, this is covered by financial powers of attorney. We do 2 documents for our clients, and the reason for the 2 documents is that by having the 2 power of attorney documents, we've covered 100% of situations where someone might ever need their financial power of attorney to take action on their behalf. Starting with the Maryland statutory form, that is something exactly as the title says. It's something that comes out of Maryland statute. So the legislature in the last 10 years recognized that without a standardized financial power of attorney form, people were creating their own, and frequently banks or other financial institutions were rejecting them and saying, we don't think this is a valid document. Now imagine if that happened after the person who signed the power of attorney had already lost their mental capacity. Now they are subject to court-ordered guardianship, even though they had signed a document that they thought would protect them in that situation. The legislature stepped in the last 10 years. They said, listen, we're going to create a standardized form, and we're going to make it mandatory that banks and other financial institutions accept it. But the trade-off is you have to use the form exactly as it's written in the statute. There is limited customization that can be made. It's a take it or leave it document. We take it. Now, it's a matter of counseling clients and making sure that they're comfortable with the breadth of what the document covers. But the idea is that it allows you to set forth your financial power of attorney agents. Who is it that you would feel comfortable and would want to be able to access and manage your money, to pay for your needs and expenses in the event that you needed them to? So it allows you to set forth those people, those agents. It gives a general overview of powers. It allows you to set forth at what point it would be effective. And this is another counseling topic because every client is different. People are often surprised that a financial power of attorney form is actually effective immediately, unless you state otherwise. And often people say, why would I want it to be effective immediately? Well, there are several situations that I can think of, one of which is very relevant right now. What if you need to stay at home for your health and safety, but something needs to be done out in the world for you or your finances or an asset or whatever? Even though you have your mental capacity, if it's really better for you not to leave the house right now, having an immediately effective power of attorney can serve a purpose. So there are scenarios where it can be a good idea that it's immediately effective, but it doesn't have to be written that way. That is something that we can customize. And some clients feel much more comfortable saying it's only effective when I actually become incapacitated, as evidenced by physicians declaring me incapacitated. Now, what about this second power of attorney document, and why do we do that? So the general durable financial power of attorney is meant to supplement the Maryland statutory form. The 2 go hand in hand. They do not replace each other and they do not revoke each other. They go hand in hand. The fact is that the Maryland statutory form covers about 95% of situations, and the general durable financial power of attorney is meant to cover those additional 5% of situations, including the fact that it comes as a surprise to many, the Maryland statutory form and Maryland law with regard to powers of attorney does not actually provide for compensation, meaning that someone acting as your power of attorney does not necessarily have the right to be compensated for their time. That is an example of something additional which we cover in the general durable financial power of attorney. It also covers a few additional situations that we're very familiar with in our practice, particularly with regard to elder law and special needs planning, which is primarily meant to provide authority to your power of attorney to do asset protection planning that may need to be done in the event that you either do become incapacitated or are potentially facing skilled nursing expenses. And it's worth the conversation to have to see if there's some sort of asset protection that can be done to prepare you for Medicaid long-term care to help pay for skilled nursing. So the financial powers of attorney are twofold. By having both documents, you've made sure to protect yourself against the risk of incapacity and court-ordered guardianship, and to make sure that you've provided your financial agent with full authority to do whatever it is that they may need to do to act on your behalf with regard to your assets. Jeff, that may be a good stopping point to ask if there are any questions.
Thanks, Olivia. No questions so far. I think everybody's listening intently, so don't be shy in asking questions, everybody. That's what Olivia's here for. Thanks,
Excellent.
Olivia.
Thank you. So the question then, who to name? And this is something that really is particularly common when I am working with individuals. Because when I am working with individuals and they feel, well, I don't necessarily have anyone either that I would want to burden with the responsibility of being my healthcare agent or being my financial agent, or I don't have anyone who I necessarily trust to serve in that role. So a big part of the conversation is who? And of course, there are many options, and it's a matter of just talking through the choices and who it is that you have in your life and talking through what it means to really assign this responsibility to someone. So while it is often true that in a married couple or in a situation where a single person maybe has adult children, often the spouse or the adult children are kind of easy go-to choices for whom to name as your healthcare agent or your financial agent. But the reality is that is not always the case, because again, it's a matter of trusting that that person will act appropriately. They are, under the law, absolutely supposed to act in your best interest and follow the terms of the document. But it's still a situation that involves quite a bit of trust that this person is going to carry out that authority appropriately. And it can be a significant burden. Not always, but it's certainly worth thinking about, is it fair to task this person with this responsibility? And I will say, with that thought, it's not a bad idea to have a conversation with someone. If you are thinking about naming them in that role, I recommend that you discuss with them what that role entails and whether they would be willing to do so. Now, something that I always tell people is, just because you've named someone to act as your healthcare agent or to act as your financial agent, it does not mean that they are obligated to do so at the time. They are always allowed to resign or to simply say, no, I'm not going to act in this role. That's a double-edged sword, because on the one hand, that means if you're talking to someone and right this moment they say, I really don't feel that I could handle it right now, but maybe in the future I could, and you feel, well, this is the person that I would want the most to serve in this role, then I think it's okay to name them, because if and when it is ever relevant, they may be able to handle it and it may work out fine, and it was your preference, so that would work. And if not, then they don't have to. But that leads to my emphasis on how important it is to name backups. So it's always a good idea. I urge people to name at least 3. So a primary and then at least 2 backup agents, just because that way you have protected yourself against the risk that the person that you've named may not be able to do so at the time. This also leads me to emphasize something that I always want to remind people of, which is the importance of updating the documents regularly. So the starting point is have a plan, but then it doesn't mean that it's meant to last forever. And I'm sorry about that. I know that it seems like it should be a one-time thing. You put your plan together and then it's done. Unfortunately, that's just not realistic. I recommend that people update their plan about every 5 years. I think that's just a good rule of thumb. Obviously, if anything changes in the meantime, you want to update the plan more regularly, but at least every 5 years, revisit it. And that will help capture maybe this person was appropriate 5 years ago, but they're no longer appropriate. And now maybe someone new is appropriate. So amongst the choices to think through, the starting point for many people is relatives, thinking about whether there's any family member who you trust and would want to assign this responsibility to, or thinking about trusted friends. And kind of at the end of the line, and certainly not a bad choice, is thinking about whether there are any professionals with whom you work that you would feel comfortable assigning this role. Particularly with professionals, I do recommend discussing it with them because certain professionals have professional obligations that prevent them from being able to serve in certain roles. But professionals are always a good option, whether it's naming your financial planner or naming your CPA or naming your estate planning attorney, or just generally, many banks and financial institutions do offer certain services that allow them to fill these roles. The trade-off with naming professionals, on the one hand, you have a certain higher level of certainty and confidence that the role will be carried out appropriately. On the other hand, one of the downsides of naming professionals is that it does come with more cost. So everyone serving in these roles is entitled to compensation, but a professional serving in these roles has a higher level of compensation typically. And so that's just part of the thought process. So incapacity planning, protecting yourself against the risk of guardianship, making sure that you've outlined who and how someone could handle your healthcare and your finances on your behalf if you're still alive and need that help. Then there is, of course, after death planning and talking about what it means to have some sort of plan in place for after death. And I'm going to talk about the two basic estate planning documents that are most commonly used to plan for what happens with your estate after death. Last will and testament versus revocable living trust. All right, last will and testament. So the first thing I want to emphasize is that a last will and testament is subject to probate. Many people think, I have a will, therefore nothing will have to go through probate. That is not true. A will is a document that tells the probate court what you want to happen with your estate, but it still has to go through the probate court. So I guess let me start with that. What does probate mean? Probate is a court-supervised process administering someone's estate after their death, and it's necessary for any asset on which there is no living owner and no designated beneficiary. So the starting point is there an asset with no living owner and no designated beneficiary? If the answer is yes, then in order for it to go from the now deceased owner to the recipients, whether they are heirs or beneficiaries or legatees, it has to go through probate. If there is a will, the will is what directs what happens with probate. If there is no will, then the statutes dictate what happens with the probate estate. So a last will and testament is a document that sets forth one's intentions with regard to one's probate estate, but it does have to go through that court process. Probate is subject to public oversight, so anyone from the public, and I mean anyone, can go and ask for a copy of the will and ask for copies of the estate documents. The probate process involves opening the estate and then filing the various inventory and accounting paperwork that the court requires, because the court needs to be able to make sure and verify that assets are being handled appropriately. And it involves waiting for any valid creditor claims to be filed. So the point with emphasizing the probate process is that it is a process. It does have paperwork and filing and documentation requirements, and it does have certain timelines, which means that it can cause some delay. And typically the cost of probate on average, we find to be about 4% of the size of the probate estate. So what happens when someone says, well, I would rather avoid all of that? And I apologize, here's my will-based estate plan. If you proceed with a will-based estate plan, you have a will, you have your advanced medical directive and most, and you have your financial powers of attorney. And this is a comprehensive estate plan that deals with incapacity and after death. But it also will result in probate. So when someone says, how do I avoid probate? First of all, it's always a source of a little bit of humor, because of course, when we're talking about avoiding probate, you will no longer be here. So you're not avoiding probate for yourself, you are avoiding probate for the people who will be dealing with things after you are gone. This distinction between probate and avoiding probate is something that I find to be very relevant with my single clients, in part because when they are thinking about who is it that will be handling things after I am gone, and to what extent do I want to avoid probate for that person? So I'm going to talk a little bit more about that, but first let me talk specifically about avoidance of probate using what's called a revocable living trust. So a revocable living trust is a document, just like a will is a document. A revocable living trust outlines what you want to happen with your estate after you are gone, just like a will does. But the difference between the two is that a revocable living trust comes into existence when you sign it, which is while you are alive. And the next step is that we actually retitle your assets into the revocable trust. And so while you are alive, your assets, now caveat there, not every single asset. There are nuances to certain types of assets and tax treatment. And so we don't retitle everything, but for the most part, we retitle. For assets that we don't retitle, we handle those in other ways, such as beneficiary designation forms or payable on death registrations. We have an approach for everything, I promise. And ultimately, the point is making sure that all of your assets are properly structured with your trust plan. While you are alive, your revocable living trust owns certain of your assets. That strikes fear in the hearts of many. Wait a minute, I want to own my assets. I don't want something else to own my assets while I'm living. But not to worry. Your revocable trust is revocable by you. You are your own trustee. It is associated with your Social Security number. So while you are alive, it's really just an alter ego. You're still in charge of your assets. You can still do whatever you want with them. But at your death, the trust becomes irrevocable. It does not die because it is not human. It's an entity. And what happens at that point is your successor trustee steps into position and follows the terms of what the document says with regard to what you want done with the trust assets after your death. So that is how a revocable trust actually avoids probate. The pivotal thing about it is what's called funding, because if the assets are not structured properly to flow pursuant to the trust, then it may not actually avoid probate. And something I always want to emphasize is what a revocable trust does not accomplish. It does not give you creditor or asset protection while you are alive, and it does not give you tax savings. It accomplishes avoiding probate. And on average, we do find that the cost of trust administration is typically 1% to 2% of the size of the estate. So now getting back to this conversation about single people thinking about whether or not they want a document that will avoid probate and whether or not they want an estate plan that will avoid probate. And what I will say about that is one other distinction between the last will and testament and probate and a revocable living trust and avoiding probate. I already talked about the distinction in the cost after death, the idea of kind of the 4% versus the 2%. But the cost up front is also a distinction. A revocable living trust is a more complicated plan and it requires more work. So for you as the client, a revocable living trust comes with a bit more upfront cost and a bit more upfront work. Whereas if you choose to utilize a will, what you're doing is saying the cost and the work are going to happen after my death. So when I'm working with single clients, it's fascinating because some of them say, I don't want to leave the burden of probate or the costs of probate. I don't want to leave that for my friend to deal with or, to have that be a burden that I leave on anyone. Other people say, what do I care? I'm going to be gone. And it's not like I'm worried about protecting my spouse from having to deal with probate or protecting my children from having to deal with probate. It's going to be my estate planning attorney who's dealing with it or my financial advisor, and they're going to get paid. So I'm going to choose to go with a will and pay less upfront and do less work upfront, because after I'm gone, I'm not worried about preventing the work for a spouse or children or a friend or anyone else. So this is just all part of the counseling and the conversation and the discussion that I would have with you with regard to these different specifics and what type of estate plan most appropriately addresses your order of priorities. So a revocable trust-based estate plan is one that looks like this. It's a revocable trust as the foundational document with the advanced medical directive and of course the MOLST being part of that bubble, and then the financial powers of attorney, and then also what's called a pour-over will and assignments, which are just ancillary supportive documents that go along with a revocable trust. So some special considerations, and these are relevant to most people, not just single people, but I find it can be particularly relevant when we are talking about single people, simply because there can be the concern that I am the only one taking care of this person, or I am the only one taking care of this situation. I don't have a spouse who's going to be able to take care of it if I can't. So some special considerations applicable to everyone, but sometimes very applicable to single clients, and specifically talking about beneficiaries, so the people that you plan to benefit from your estate after your death, and or dependents, those who are dependent upon you while you are alive, and what will happen with them and their care after you are gone. So going through several of the topics that fall under that heading, first there is inheritance tax. Maryland is one of the few states that has what's called an inheritance tax. Amusingly, it is what's used to actually fund the Register of Wills offices. The inheritance tax is a 10% tax. It is assessed against certain relationships, meaning certain people who stand in a certain relationship with the deceased person. It's a tax assessed against those people inheriting. So what I mean by that is, for example, if my cousin left me $1,000 I, as a cousin of the deceased person, my $1,000 inheritance would face a 10% inheritance tax. Frequently for single people, there is a relevant piece of the conversation with regard to inheritance tax because it is assessed against friends, cousins, nieces and nephews, basically anyone who's not a parent or a grandparent, a child or a grandchild, or a sibling. So anyone outside of that lineup is facing inheritance tax. And it's just a relevant part of the conversation with regard to a client's intentions as to whether that inheritance tax is to be paid out of the inheritance itself or out of the estate as a whole. Income tax is always a topic. Income tax is always a relevant thing to think through and talk about, simply because it is relevant with regard to certain assets after death. Income tax is something that's relevant both to qualified retirement accounts and qualified retirement assets. Those are assets that have not ever faced income tax. The IRS is not going to let you get away with that forever, as you all probably know. And so income tax, when we're talking about pre-tax accounts, such as qualified retirement accounts, income tax is a relevant part of the conversation with regard to how those assets will be inherited and what the income tax consequences will be, because it's different depending upon the recipient or the beneficiary. It's also a relevant conversation with regard to the idea of capital gains tax. And with that, specifically thinking about what is the tax basis and what would the step up in basis or step down in basis be, depending on how the plan is structured. All of that falls within the income tax category and is simply an important part of the conversation. Again, with regard to any estate plan, but it can be particularly relevant with single people because there are certain income tax benefits that can accrue to spouses and children that won't necessarily accrue to friends or nieces. With regard to minor children, so if you are a single person with minor children, this is a particularly relevant and important consideration, because in order to make sure that you have designated the person or people that you think would be the most appropriate to be the guardians of your minor children in the event that you pass away before they are 18, you must have documents in place that say that. And if you don't, then it is something that can be left open to the court to decide and to individuals who may step forward and say they should be the guardian, which of course can also lead to arguments. So it can be very destructive if there are multiple friends or family members fighting it out in court over whom should be the guardian of the minor children, which can be cleared up and avoided if there is a document in place where a parent or the current legal guardian sets forth who the legal guardian should be in the event they are no longer able to be. And then with regard to incapacitated individuals or individuals with special needs. So if you are a single person or not, if you are any person who is taking care of an incapacitated individual or an individual with special needs, this adds a level of complexity to what would be if you could no longer be the person taking care of that incapacitated individual or that individual with special needs. That is a vital situation to make sure that you've planned appropriately for, not only with regard to having documents that dictate who would step in and how would that person be taken care of if you couldn't, but also structuring assets and finances and inheritances appropriately for those individuals. Because when we're thinking about incapacitated individuals or individuals with special needs, it does take an extra level of planning with regard to how they would inherit money in such a way that not only would they still be eligible for any government assistance that they might be eligible for, but also to make sure that the money is structured in a way that it will be used to pay for their needs and to pay for their care, rather than, for example, ending up in the hands of someone who really doesn't have the capacity to manage money for themselves. So thinking about incapacitated individuals or individuals with special needs and planning for their care after you are no longer around is something that is very important to do and to put into writing, because otherwise it can be a complete bust. And that certainly would not be your intention.
Olivia?
Yes.
We do have a question that I think is a good one that probably many people do have, so I wanted to ask it of you. The question is from a good friend of ours for the firm. Is there any target age or income/asset level where it is vital for an individual to examine their estate planning?
So that is an excellent question and a very common one. First of all, the answer that I have with regard to age is that as soon as you are 18 years old, you are an adult in the eyes of the law. And accordingly, if you trip and fall and hit your head and suffer a traumatic brain injury, and you are 19 years old and you never signed an advance medical directive or a financial power of attorney giving that authority to someone else, court-ordered guardianship is going to be your reality, and whether your parents have to seek that over you or whomever it may be. So it's very unusual and rare for young people to have situations that arise where this is a risk or a concern. But the literal application of the law is, as soon as you are 18, it is a good idea to have documents in place to protect yourself against the risk of guardianship. So that's an answer that I'll give with that. And what that really means is everyone. At every age above the age of 18, I recommend that you have at least the basic estate planning documents in place. As time goes by and as you perhaps accrue more assets, really speaking in terms of once you start to own anything on which there is no designated beneficiary. And what I mean by that is many young people, when they start their first job, maybe they'll have a 401k plan through work. That is an asset where there is a beneficiary designation form. And that is what will control that asset at death, and that is what will avoid probate on that asset. So it would really more so be with the purchase of a home or opening any sort of account on which there is no beneficiary designation. That's when I would really encourage at least having a simple will in place, because wanting to make sure that there is something in writing to control what would happen with those assets if you died. So incapacity documents, I recommend those from the age of 18 and up. I'm sure you all can guess that not a lot of 18-year-olds come into my office to see me, but that is kind of the rule that I would put out there is if you are over the age of 18 and having this conversation, it's a good idea to have these documents. And really, once you start accruing assets, and especially if you have children, now is the time to get an estate plan in place. With regard to thinking about at what point and asset level does it make sense to talk about a will versus a revocable trust? Thank you for that question, because frequently people incorrectly think trusts are only for the wealthy. I hope that what I've covered here helps clear that up, because that is inaccurate. Trusts are not only for the wealthy. Trusts are for people who want to make sure that probate is avoided at death and who have assets that would be subject to probate. So that is not limited to the wealthy. And really, that's just a matter of counseling and having the discussion of what are the types of assets and what are your goals and concerns with regard to what would happen after your death. And that's what leads us down the path of whether a will versus a trust is the right idea. So I hope that that helped answer that question.
Thanks, Olivia. We do have one more. Speaking now being the time, now is the time to put those questions out there. I know Olivia has a busy rest of the day and day tomorrow, so if you want a question answered from her knowledge bank, now is that time to make sure you get it in here. So, so thank you again for this question. The question is, should long-term care be part of the planning for an individual?
So that is also an excellent question. So with regard to long-term care, I think that's something that covers several different topics. Long-term care, when we're talking about how will I pay for it, and frequently when we're talking about long-term care insurance, that is when I loop in the other members of what we call an advisory team. So what I will say about that is every individual benefits not only from having an estate planning attorney, but also from having a financial advisor, and certainly frequently from having a tax expert. So whether that's a CPA or some other tax advisor. Those are the three professions and areas of expertise that have tremendous overlap. Those are the three areas of expertise that most people truly benefit from. And something that I always recommend with clients with whom I work is, if you don't have a financial advisor, please let me introduce you to one. And that means then when we're talking about, is long-term care insurance something that you should think about, that's where the financial advisor is going to be able to really help guide on that question. But in terms of making sure that you have the maximum protection in writing with regard to an unknown future, unknown with regard to whether you will have skilled nursing and assisted living expenses, whether or not you will have mental capacity at that time to act with regard to your assets as you may need to protect them to the greatest extent possible and to maximize them for your own care. The best thing that you can do is early on, when you're still healthy, have the right documents in place to make sure that if you lost your mental capacity, you've given the power to your power of attorney and potentially to your trustee to be able to do that asset protection planning at that time when it becomes necessary and you aren't able to do it for yourself. So we call that pre-crisis planning, and basically having a fundamental estate plan in place means that you have done what you can from a legal perspective with regard to being prepared for when a crisis may take place. And if you're not able to do asset protection for yourself, your trustee and power of attorney will be able to do so. And then if we're actually in crisis mode where long-term care is a relevant issue now and not potentially in the future, then there are certainly things that we can do called crisis planning, where we can implement Medicaid asset protection trusts. We can implement a gifting strategy that's approved under Medicaid law. We're able to do those things if we're in crisis mode. If you have mental capacity and you're in crisis mode, you can make the decision to do that with your own assets. We can help you. If you don't have mental capacity and it's crisis mode, that's where it's so vital that you've signed powers of attorney and trust documents, giving someone else the authority to do that for you.
All right, one more, Olivia. Thank you for that answer. A pretty, I think, straightforward but very important question. Is a durable power of attorney effective immediately as well?
So a durable power of attorney is effective immediately if that's how it's drafted, and it's effective only upon incapacity if that's how it's drafted. So whatever decision is made with regard to at what point do you want your financial power of attorney to be able to act, that's the decision that you make in counseling with me, And then that's the instruction that's put into place in the Maryland statutory form and in the durable power of attorney. They mirror each other with regard to that so that they work together.
All right, thank you, Olivia. We just had a comment from the person who asked a recent question. It must be very hard to convince 18-year-olds to engage in estate planning. I guess the driving force sometimes needs to be the parents or perhaps the grandparents sometimes. Would you say that's a fair statement?
That is absolutely an accurate statement. I have yet to work with any 18-year-old who's come on their own behalf, simply because they're typically focused on a few other things happening in life at that point in time. But it is fairly common that if I'm working with parents or grandparents, that when we're having these conversations and they become aware of the fact that this is something that's important for every adult, no matter the age, frequently that is something that that will lead to bringing the children in or the grandchildren in just to sign those basic incapacity planning documents.
Makes sense. And hopefully it wouldn't take away from their fortnight time very much.
Yes, there you go.
I think that's it for now. Let me just double check and then we can move forward. Actually, one more, sorry, but glad to see questions. How does an individual plan for Medicaid coverage if long-term care, well, let me see if I'm reading this correctly. How does an individual, I'm sorry, okay, here we go. How does an individual plan for Medicaid coverage if long-term care is not an option? What is meant by skilled nursing?
Sure. So skilled nursing is basically a nursing home. So skilled nursing is the highest level of medical care. It's the highest and most expensive level of medical care. That's what I mean when I say skilled nursing. And if someone is in a situation where, so, you know, all of this is a spectrum, obviously, and at various points in life, we fall on a different point on the spectrum. And so it's impossible to specifically say this would be exactly what you need to do without having the actual specific conversation with that person with regard to their current health status, their current financial and asset situation, their current family situation, their goals and concerns. All of that goes into the discussion to decide what is the best plan for this specific person. But what I can say as an overview is that if you're on the end of the spectrum where you are healthy and the risk of skilled nursing is a distant risk, again, none of us know when anything's going to happen, but for most of us, if we're following kind of the typical path of life. So if you're at that point in the spectrum, you're healthy and the risk of skilled nursing seems distant, then what I recommend is that you have the fundamental documents in place that make sure if you don't have capacity because something unexpected happens and you end up needing skilled nursing, you've put in place the documents to allow your financial power of attorney or trustee to implement the asset protection planning at that moment in time. If you are at the point in the spectrum where you're starting to feel a little bit anxious about the future and skilled nursing maybe being closer than it used to be, and that it is something that could be part of your reality in the next 10 years, then that's a different point on the spectrum, and that requires simply discussing what is it that you are comfortable doing now with regard to your assets in exchange for the benefit that may or may not happen, because of course you don't know the future and you may still not actually need skilled nursing. And so if you implement this type of plan, which is specifically focused on asset protection, it may not pay off because you may not actually need the skilled nursing. And that's part of the conversation, particularly because part of it is giving up control of assets, and part of it is creating some irrevocable plans and giving up control of some assets. That's why it's not something that people do overly prematurely. So I would say if you're at that middle point where you feel you're beyond maybe the age and the health where you can obtain long-term care insurance, but you're also starting to feel very concerned about rising healthcare costs and what the future holds, that is a very, very relevant time to have this conversation and to discuss all of the nuances and all of your particulars so that you know what your options are and you can feel comfortable with the decision that you make now. And you know that if you want to make a different decision in a year or in 3 years, that you'll at least know what the path is in front of you and what options you have. I think that brings a lot of comfort. So that's how I would answer that, is that there are options. They just are multifaceted, and it's something that's worth having a discussion about.
Okay, let's try one more. As a quick sidebar, for those interested, we do have a very specific discussion about the differences between assisted living facilities and skilled nursing facilities next Tuesday, offered by our elder law attorney, Lindsay Moss. So you should have received an invitation about that. If you want to get further information or you didn't receive an invitation, just let me know and I'll be sure to get you one. The last question for now, living revocable trusts, do they avoid probate? I thought only irrevocable trusts do. What is the difference between and why having a living will or with IRT, irrevocable trust? I guess that is. Does that make sense, Olivia?
I think so.
Okay.
So, and I'll answer, and if the person had a more specific question that I'm not answering, then they can let you know that. A revocable trust avoids probate. That's kind of what it accomplishes. So a revocable trust avoids probate. It does not avoid taxes, and it does not provide asset or creditor protection. It avoids probate. An irrevocable trust also avoids probate, but it has additional hallmarks to it. And those additional hallmarks are typically asset protection, creditor protection, sometimes tax savings, control and management aspects. So a revocable trust avoids probate. Period. An irrevocable trust avoids probate and accomplishes additional things. There are many, many different types of irrevocable trusts. In the name you hear irrevocable. That's why those are not implemented unless there is an additional motivation to do so. So if someone's motivation is to avoid probate, a revocable trust accomplishes that, while also being revocable, which means that the person who creates it still has full control. They can still change the terms of the document. They can put money in and out. They have full control, and it avoids probate. So if someone's goal is avoidance of probate, revocable trust is step one. If there are additional motivations, additional concerns, such as asset protection, creditor protection, preparing for skilled nursing and Medicaid, if there are special needs that are relevant, if there's certain tax planning that needs to be implemented, if there's an individual who really can't be responsible for managing their own funds, all of those are reasons that we have conversations about irrevocable trusts. And again, there are many different types, so which type is specifically applicable and best for the situation requires talking through the details of the situation. But all of those avoid probate. It's just revocable trust, that's kind of what it accomplishes. Irrevocable trust accomplishes additional things depending on what's needed.
Okay, thank you, Olivia. We do have a couple more questions. If you'd like to maybe move forward with some more slides, we can certainly address those other questions in a few minutes.
Sure. Well, I think we're pretty much at the finish line because, well, I'll cover this a bit. So other non-probate devices. All right. So I talked about will versus revocable trust, talked about the fact that a will is something that goes through probate and that controls where the probate estate goes. Revocable trust avoids probate. Also talked about irrevocable trusts also avoid probate. So trust planning avoids probate. Other devices for avoiding probate are joint ownership. At the death of one owner, the asset passes to the surviving joint owner, does not go through probate. Payable on death, transferable on death, beneficiary designation, those are all structures where the asset passes to the beneficiary at death without going through probate. And life estate deeds are a type of deed where it's set up in such a way that at the death of the life estate tenant, it passes to what's called the remainderman without going through probate. But let me caution and urge all of you listening, please know that as an estate planning attorney, I would never, never, never recommend that you rely solely on these structures as your estate plan. So let me say that again. I do not ever recommend that you think, I want to avoid probate and I'm going to do it by just making everything payable on death. Please don't do that. There are several reasons why. I'm happy to discuss further with you in a one-on-one counseling session. But what I will say as a general statement is that that comes with a lot of risks that do not come when you have a will or a trust as your estate plan. So an estate planning attorney will tell you, and estate planning, special needs planning, asset protection planning, tax planning, I am all of those things. And I am telling you, the best plan is one that involves a combination of all of this. But it is not something that relies solely on one type of structure versus another. And no matter what, it's a good idea to have the conversation to make sure that you are aware of the risks and that you're making the best plan for your assets, your intended beneficiaries, and taking into account all of the risks that I can discuss with you. But doing these non-probate devices in and of themselves is not sufficient. And that's why I show this as it's intended to be either a will or a trust, plus maybe some combination of these other devices. And I do think that's where we reach the finish line. So the point is put it in writing. I mean, that's really the point. Having it in writing will avoid many risks. It will avoid many headaches and situations that could be avoided if there was just something in writing. So do your estate plan. And with COVID-19 and now a tropical storm and who knows what the future holds, do it as soon as possible. All right, Jeff, any other questions?
We do have a few, and thank you all for the great questions, and give Olivia a virtual hand for a job well done, and thanks for the great information. So another question from an attendee says, hi, Jeff and Olivia. Thanks for this webinar and valuable information. Certainly our pleasure. Thank you for attending. Congress passed the Secure Act, and then end of 2019, changing most scenarios for inherited IRA accounts where the named beneficiary would need to liquidate the account within 10 years. Is it more beneficial to name someone outright versus naming a trust, since trusts are taxed at a higher tax rate? That's a really good question.
That is a really good question. And with so much of this, I have to apologize because they are more nuanced conversations that need to be had for a specific person and their specific beneficiaries and their goals and concerns. But here's what I'll say just as kind of a quick answer to that. It is true that trusts are taxed at a higher tax bracket than individuals. That is a factual statement. What that means is that it's always an important part of the conversation to figure out and put into place the plan that will address that reality, which is that trusts are taxed at a higher income tax bracket than individuals. And given that, what discretion do we want to build into the trust with regard to distributions of income? So knowing that trusts are taxed at a higher income tax bracket than individuals, and then talking about the particular individuals that are relevant to the plan, and then figuring out what discretion should be built into the trust with regard to income distributions, so that at the point in time it's relevant, the trustee can determine whether to keep the income inside the trust where it will be taxed at that higher bracket, or distribute it out to the individual where it would potentially be taxed at a lower bracket. That conversation also has to take into account asset protection, because part of what we're talking about is taxes, but a flip side of that is asset protection, which is maybe in a particular situation, it's unfortunate to pay higher taxes, but if it would actually end up protecting a greater amount of the money by keeping it shielded in the trust because maybe the beneficiary is going through a divorce, that's just all part of the conversation to help achieve the right document and the right plan. And with regard to whether or not to designate individuals versus trusts as beneficiaries on inherited retirement assets, the fact is that yes, under the Secure Act, now certain beneficiaries do have to liquidate in 10 years. But over the course of that 10-year period, would we want that inherited IRA, for example, to have asset protection? And in order for us to accomplish that, we do still need to have it beneficiary designated to a trust. If it's beneficiary designated to an individual who is a non-spouse, it does not have asset protection against their creditors or the risk of divorce. So a long-winded answer simply to emphasize it's always more complicated, but that's why it's worth having the specific discussion about the particular beneficiaries and the particular goals and concerns.
Thanks, Olivia. Another question from a good financial advisor friend of ours, Jerry. Hi, Jerry. It's good to see you on here. I miss seeing you at our events that we have in our office. Hopefully we can get back there soon. The question is, if one's IRA beneficiaries are the children, why run those assets through a conduit trust rather than name them directly as the beneficiaries?
So again, because designating those to trusts provides asset protection, whereas designating those to individuals, if they're the children, does not. So asset protection is the answer. And with regard to the conduit language, that is something that has changed significantly because of the Secure Act. So that's a counseling conversation. That's part of talking through the specifics with regard to the particular client, their particular intended beneficiaries, and all of the kind of outside concerns that play a role in it, whether creditor protection, asset protection, divorce, all of that playing a part in the conversation. But conduit language was what we used pretty much across the board prior to the Secure Act. And now we're really shifting gears, of course, only after having the conversations with clients and their financial advisors, but shifting much more often now to what's called accumulation trust planning, in light of the fact that the conduit trust language prior to the Secure Act allowed for the lifetime stretch out. Now that's not a relevant part of the conversation anymore because Congress took that away. And so now conduit versus accumulation is just part of the counseling that we do with clients and their financial advisors. But no matter what, I can answer the question, beneficiary designating to a trust, the reason to do that is because of the added asset protection.
Very good. Looks like we have just a couple more questions from another good friend of the firm. Hi, Ann. Say hi to Gary for me. A good question: is inheritance tax paid on non-probate devices when the beneficiary is not exempt?
Yes. So just because something does not go through probate, it is not free from inheritance tax.
Okay. Let's see, and question I can answer actually. It says, thank you very much for all this great information. Will these slides be made available to us later? Actually, I did email these slides out to everybody yesterday. So please do check your email. You should be in receipt of that. If you did not receive them for some reason, please email me at Jeff, Jeff, at elvilleassociates.com, and I'll be happy to send it back to you. Or I see your name actually. I'll just go ahead and resend it to you. So I'm just going to jot your name down here, Peter, and I'll resend that to you to the email I have on file. So, and anybody else that did not receive it for some reason and would like it, please just go ahead and email me and I'll get that out to you before the end of today. Let me see if we have any more. And I think that's it. So as I'm giving some closing comments, if there are any final questions, now is your time to pose those. I'm going to jump back on camera here briefly and want to again thank you to Olivia for a great discussion, and thank you to our attendees for making it a great discussion with all of your great questions. And we have a busy webinar month in August. We have, along with kicking it off with a great discussion today, we have a special needs presentation on Friday with Steve Elville, our president and principal attorney. It's a very, very popular presentation. As I alluded to as well, we have one next Tuesday, a discussion about the differences between assisted living facilities and skilled nursing facilities. So that's the first time we're offering that and are excited about that. Also Friday, the 14th of August, we have a discussion by Steve regarding choosing the right trustee for you. So we're really looking forward to that as well. And a number of others later in the month that we'll share with you through invitations as well. Lastly, please just take a couple minutes to fill out the survey that you're going to be receiving in the next few minutes. We really value your feedback. It's a great time to let us know how we did today. Maybe give us some ideas about some topics that you might like to see in the coming weeks and months. And also, if you have an interest in scheduling that consultation with Olivia to talk about your personal situation and get some further education and counseling for your individual situation. Again, no better time than the present to put it in writing and get that plan in place for that unforeseen situation that hopefully won't arise, but you never know what could happen, as we all know in this unusual year that we're all facing together. So you can scratch it off your bucket list as well. You can always email Olivia or me as well if you have any further questions or thoughts. We always appreciate that, and we'll be happy to give a response back to you. So some valuable education today. If you have any questions, please do reach out to us with anything that you need. And it looks like we might have one more question. We're happy to answer. Before we wrap up, looks like right on time. And it looks like we have a question that could be an entire webinar, but still a great question. Olivia, could you talk a little bit about gifting strategies?
Certainly, and you're absolutely right. That is a good suggestion for a future topic to cover.
Yes, it is, yeah.
So I guess thinking in terms of gifting strategies, and I'm assuming that the question is really focused on with regard to Medicaid asset protection planning. I mean, I will say, so as I mentioned, you start on the side of the spectrum where you're saying, I'm at a point in life where I'm healthy and I'm not overly concerned about future healthcare costs or future anything. I just want to make sure that I have a basic estate plan in place to protect myself against the unknown. And that is the pre-crisis planning. And part of that, as I mentioned, is making sure that you have a robust power of attorney, and if you decide to utilize trusts, a robust trust. And part of the robust aspect of that is providing for a financial power of attorney or trustee acting on your behalf to have the ability to engage in gifting. And when I review that aspect of the documents with clients, I say, this literally means the ability to give away your money. And obviously that causes fear in the hearts of many, that you're giving someone else the authority to give away your money. Why would gifting be something that would ever be necessary or applicable? And then I go into the fact that there are two main reasons. One is tax avoidance. If your estate plan is such that at your death, there may be taxes assessed against those individuals inheriting from you, whether it's inheritance tax or perhaps your estate is sizable enough that estate tax is a concern. If there's any kind of tax consequence that may occur from assets after your death going to particular beneficiaries or whatever, sometimes that's why gifting is done, to avoid those tax consequences by gifting during life. And that's something that we do frequently. I'm working with a family where the mom is incapacitated and has an estate of over $5 million. If she has that size estate at death, Maryland taxing authorities are going to get a piece of it. So we've engaged with her children in a gifting strategy to respect mom's estate planning intentions, which thankfully were all written in documents that she signed when she still had capacity. We're engaging in a gifting strategy to respect those wishes, but to try to do so at a time and in a manner that will minimize the tax exposure. So that's one kind of reason for a gifting strategy. But the other reason for gifting, and the other thing I cover with clients when I'm reviewing documents and I'm pointing out you're giving someone the power to make gifts of your assets. It's for tax avoidance reasons. It also can be a very important tool in Medicaid asset protection planning. And basically the gifting strategy there, without going into too much detail, because we'll do a future webinar on that topic. But really what we're talking about there is that Medicaid rules penalize certain transfers of assets that have been made. And Medicaid has what's called a 5-year look back. So Medicaid wants to know, what assets have you had in the last 5 years and what did you do with them if you no longer have them? Certain transfers that you may have made of your assets, you would face a penalty. But there are allowable transfers and there are allowable mechanisms for basically getting rid of your assets in order to be eligible for Medicaid to help pay for skilled nursing. And one of those allowable strategies is gifting. It's called a half-loaf strategy. And the way that I kind of quickly explain it to clients is the idea is gifting half of your assets to a person and loaning half of your assets to the same person. And they pay back the loan with the gift, and that's allowed. It's more complicated than that. That's a very basic way of summarizing it, but that's something that we are able to utilize in crisis moments, crisis times, when we're working with clients who have too much money to qualify for Medicaid long-term care, and we're wanting to do something to try to protect assets and to get them eligible for the Medicaid long-term care. The half-loaf strategy, which is a gifting strategy, is one of our options. And that's why I emphasize to people how vital it is to make sure that you have financial power of attorney, and maybe also trust documents that provide that power to your financial agent. So if you're incapacitated and can't do it for yourself at the time that it's necessary, they would be able to do it for you. So I hope that was a helpful answer in a fairly quick way.
Well, thank you, Olivia. And last question, any quick thoughts around the veterans benefit, the VA aid and attendance?
Sure. So VA aid and attendance, again, the quick and dirty, what I talk to people about when we're just having the initial conversation. So Medicaid long-term care pays for skilled nursing. That is not assisted living. There is a benefit available to help pay for assisted living or in-home care costs, but it's available for certain eligible veterans. It's called aid and attendance. It is available for certain eligible veterans and their spouses, but eligibility pivots on dates of service and type of service and costs, whether they are assisted living or in-home care costs. That's part of the eligibility conversation, and available assets. So qualifying for VA aid and attendance to help pay for the costs of in-home care or assisted living pivots on qualifying based on service and costs, medical costs that are being faced, and income and available assets. But those are also areas where we have strategies that we can implement. Those are also situations where irrevocable trust planning is often what is utilized. So Medicaid, one of the things we can do is an irrevocable asset protection trust. For VA benefit purposes, that's something we can do, an irrevocable asset protection trust in those circumstances as well. Those require some pre-planning, and so it's really just a matter of talking about the client's specifics and concerns and assets and future and all of that, and determining what's the best thing to put into place right now and what's the best thing to potentially put into place in the next few years. Let's revisit it. But again, with any type of irrevocable trust planning, having a robust power of attorney where you've provided the power to do irrevocable trust planning, you've given that power to your power of attorney, that's the best thing that you can do while you're still healthy, because if the time comes and that needs to be done and you can't do it for yourself, you've made sure that there is someone who can do it for you.
Very good. Well, thank you everybody for attending, and I'll again be sending, as I always do, this video out. So if you missed anything or wanted to send it to a family member or friend that would benefit from seeing the information, you're certainly welcome to do that. And with that, we'll bring this to a close. The sun is actually going to be coming out in a few hours, so I know it'll be a little bit soggy, but hope you can enjoy that. And we look forward to seeing you in another webinar soon. And thank you for attending and for your support of our Elville workshop series. Hope you have a pleasant day, everybody, and have a great day.